Good morning, and thanks for joining us for another edition of the Elville webinar series. Today is Friday. Don't worry about the date. It's Friday. That's all you need to know. Our topic today is special needs planning, estate and financial planning in unique circumstances. And we have two outstanding presenters back again today to share information and education with you. We have Lilly Hummel, principal attorney and leader of the Rockville office of Elville and Associates, and Cortney Heykoop, a chartered special needs financial consultant with Clover Wealth Strategies. And I'm Jeff Stauffer, and I'll be your moderator today. I'm the Community Relations Director at Elville & Associates. So a few housekeeping items briefly. We always encourage your general questions throughout, so please note them in the questions panel, and we'll go ahead and pause periodically or wait till the end to answer some of those questions. If you have a very specific question relative to just your situation, they may be best served to be talked about in a consultation with Lilly or Cortney. Also, by email yesterday, you received the presentation slides that Lilly and Cortney will be referencing, and these materials are also available in the section marked handouts to download on your screen at this time. And everyone will also receive post-webinar feedback email right after the presentation, so please take just a few minutes to fill out this brief yet important survey to offer us your feedback about today's presentation. And a question for you: have you achieved your planning goals, or have those goals shifted since you last looked at your planning, be it legal or financial? And here at Elville & Associates, we are a resource for your family's planning needs, whatever that may be. If you're starting from the beginning, if you have older documents that need to be reviewed, an administration matter, special needs planning, or anything else, Lilly and our team are here to meet with you and answer your questions, and understand your individual situation, and offer some solutions and a path forward for you. So Lilly and Cortney, it's great to see you again. Looking forward to it. This is the second part of our series, and as we'll allude to and talk about a little bit later, we have a third part of the series coming up in June that we're really excited about as well. So thanks for being here. I'll turn it over to you.
All right, good morning, and thank you for joining us. Thank you, Jeff, for the introduction. So as Jeff mentioned, I'm a special needs planner here at Elville & Associates. I'm based in the Rockville office. I just, of course, have to give a disclaimer as we begin. The following presentation is just for education. This is not intended to be legal advice specific to your circumstances. I'd be happy to speak with you one-on-one if you have specific questions. And I am going to do my best as we go through to address the varying levels of comfort that people may have with understanding some of these special needs planning techniques. But in general, this assumes just a baseline familiarity with estate planning documents. We do have previous seminars, including our recording from our prior seminar, which goes over some of the more elemental foundational points of estate planning if you need that as a reference. So what am I covering in this part of the presentation? Taking a step back, what is special needs planning? Where does estate planning fit in with the broad array of things that families are addressing when there's a special needs component? And with that, I'm going to drill specifically down into special needs trusts and talk about ABLE accounts and how that fits into your estate planning. The last part is going to be switching gears, because when we're talking about good estate planning, it also is important to consider not just for the family members, but for the person who has a disability, who is going to have legal authority to make decisions on their behalf. So we're going to talk about the estate planning considerations for the person with a disability, and then transition to Cortney's presentation. So as you're going to see throughout both these presentations today, special needs planning is multifaceted. As the attorney, I'm looking at it through a very specific lens, which is estate planning documents and aligning your designated beneficiaries to achieve your goal. But this is really all happening in a much, much bigger context when there's someone with special needs. We're looking at benefits eligibility, which we're going to drill into, funding, budget, sort of Cortney's expertise, and all of this is also bringing in to the conversation, what is a long-term housing plan for the person with a disability? How are we managing their care coordination? And whether that person is appropriate, is going to need guardianship or has capacity to do their own planning for a financial power of attorney or advance directive. So it is a rather extensive series of considerations For the purposes of this conversation, I will be honing in on special needs planning, because when a beneficiary is entitled to assets, we have to figure out, okay, when we need to preserve their eligibility for public benefits, supplemental security income, or Medicaid waiver services. If we want them to receive inheritance or gifts, then we can't leave the money to them outright. And so that's when we get into these special needs trusts or ABLE accounts. I do think in order to understand why we're jumping through all these hoops and creating a special trust for your loved one, we do have to do somewhat of a deep dive, or at least a general understanding of the kinds of benefits at play. There is no way that I could summarize the types of public benefits. I mean, that in itself is a day-long seminar. I wanted to give a sampling of some of the most common ones that come up in my discussions with clients where we're doing special needs planning. Particularly as you have a minor that's transitioning into legal adulthood, then if they are going to need services from the state, one of the first steps is traditionally going to be applying for SSI, Supplemental Security Income, through the Social Security Administration. That is a minimum of a year-long process these days, often with then an appeal built in. There are some things we can do to try to have the strongest application going forward. But what's really crucial for that is the disability determination, because that in itself is going to trigger eligibility for a series of other benefits down the line. So SSI is usually one of the first places that my clients are starting as their children age into adulthood. It has very strict resource limits of what can be titled in their name. There are some excluded assets, but in general, if we want to talk about what's in the bank, they can't have more than $2,000 at the end of every month. So what is in their account as of the first month of every year is really important for benefits eligibility. They cannot be earning more than what's called substantial gainful activity amount. That's sort of the shorthand way that the Social Security Administration uses to gauge whether they can work and support themselves, is whether or not they're earning this amount. For 2025, that amount is $1,620 a month. So if they're earning under that, it's deemed that they're not engaged in substantial gainful activity. And so if they have a qualifying disability, then they may qualify for these benefits. The max benefit is $967 a month for this year, and that does go up a little bit every year, but in general, it's not tied to the real inflation, so it's a very slow incremental increase to that benefit. For people that are on SSI and don't work and have a qualifying disability benefit where the onset was under the age of 22, then later in life, if their parents elect their own retirement on their work record or their parents pass away, then the disabled person is entitled to transition into a different benefit category. It goes by different names. Traditionally, we called it the Disabled Adult Child Benefit. So we would talk about the DACs. So those are adult children with disabilities receiving a benefit off their parents' work record. These days, we tend to call this the Childhood Disability Benefit. There's no asset limit tied to this. So this particular benefit, it's irrelevant if the beneficiary has $1 million in the bank. But again, there is this income limit with earned income. So if they're able to work above a certain amount, they're never going to qualify for this Disabled Adult Child Benefit through Social Security Administration. And the amount of the benefit is also very different than for SSI, because it is a formula based on the parent's work record. So the higher that the parent's retirement benefit is going to be, the higher the child, their entitlement to the Disabled Adult Child Benefit will be. And I mean, I've seen these benefits in the neighborhood of $1,500, $1,600, $1,700, occasionally as high as $2,100, $2,200 after the parent passes away. So that's the left side of your screen, and that's the financial benefits that people are entitled to. And the reason that we're doing special needs trusts is because, especially for SSI, the person cannot accrue and have that money stay in their account month over month. It's important for all of these where there's an asset test to understand that the government characterizes assets differently from income. Income is whatever is coming into your account month over month, right? Asset is whatever stays in the account from the change of one calendar month to the next calendar month. So in the month that it's received as income, it's characterized as income. And then when it stays in the account and doesn't leave, then the next month it's characterized as an asset. So it's important to understand the distinction in how the government thinks about income versus assets. This also comes up very much so to qualify for Medicaid, which is also called medical assistance, because for people with disabilities, they're usually receiving supports and services through Medicaid waiver programs. Those are different in every state, so I'm just going to speak at a high level about how the waivers operate. In general, there is a monthly income limit. The most common income limit is 300% of whatever that year's SSI benefit is. So if this year the max benefit for SSI is $967 per month, then you would just multiply that by 3. It's a little over, gosh, I don't know the number off the top of my head, but that will give you the
$2,900.
2,900, right? It's like 2,901, I think, right? So thank you, Cortney. So if your child is earning over $2,901, then that's going to be a problem to qualify for Medicaid waiver. There are a few programs with different income limits, so it is very important to be very clear on which benefit you're talking about, which waiver specifically.
Hey,
And
Lily,
the resource, yes.
could I just interrupt you 1 second? Could you just
Please.
toggle your cursor? It has your bar at the bottom up there so we can see other screens.
Yeah, let me see it.
It was covering your presentation.
Oh, shoot.
Oh,
I think it exited out of the presentation. Jeff, can you
sorry,
please reshare the
didn't mean to.
presentation?
Or you are actually still the presenter, Lily. So I think if you went to your PowerPoint and opened it back up and then maybe jump to the current slide, that would probably work.
Okay. Can you stop sharing for just a sec? I need a minute to get it open. I thought I had it on my.
Sure.
I'm sorry, I think you just had your cursor was pulling up the screens on the bottom, so we couldn't see the last part that you were talking about.
Medicare part, right? Okay. All right. Hold on just a sec. All right. Okay. Jeff, you can go ahead and share again. And I will get this moved forward. Thank you for telling me, Cortney. All right, how does this look? Okay, the last piece I wanted to talk about is Medicare. Medicare doesn't have income or asset limits. It's just important to know Medicare comes into play because 25 months after a person is eligible to start receiving the disabled adult child benefit, they'll also begin receiving Medicare, which will become a primary payer before Medicaid as your health insurance. So this screen of public benefits doesn't even cover food stamps or housing or a whole list of other benefits that can come into play. But I recognize that when we're doing special needs planning for anybody, these are the sorts of considerations we have to take into account. In particular, I think the most important is protecting what is in the individual's name so that we don't run afoul of the resource limits here for SSI and Medicaid so that we can protect their benefits eligibility. So then as I'm driving towards, let's just take a sort of a standard couple that may come in to see me. They have a child with disabilities that's aging into adulthood. They never did their estate planning. And we need to talk about how to protect, make sure that whatever inheritance they would want to leave for that child's benefit is done in a way that allows that person to continue receiving benefits so that they don't have a lot of money in their own name in the future. So to do this, we have to sort of build our knowledge base, because if we just jump to the end of the very end being you need a standalone third-party special needs trust, I think for a lot of people, understandably, we're going to get lost in what does all that jargon mean. So I'm going to go through and build the building blocks with you. What is a trust? What do people mean when they say a special needs trust? What's the source of funding for the trust? So is it belong to the beneficiary, or is it belonging to someone else, in which case it's going to be a third-party special needs trust? And the last consideration is directed or pooled, basically a pooled special needs trust run by a nonprofit, or directed, meaning it's something that you have set up in your estate planning documents. So we're going to walk through this together. And the last piece is going to be the ABLE account. We'll talk about the intersection of ABLE and special needs trusts in the planning. So the first building block we need here is, what is a trust? So for those that haven't dealt with a trust before, this is a contract. It's defining the different players that have an obligation under a contract. You have the grantor, that's the person establishing the trust. The trustee is who's the decision maker and responsible for the assets in the trust. So it could be the trustee is the same as the grantors. It could be that there's successor trustees that take over down the line. It just depends how a family is setting this up. Then the beneficiary is who's benefiting from the assets in the trust. The trust, whatever kind it is, and there's lots of different kinds of trusts, will define the circumstances of distribution. So those are the terms and conditions. It's generally a private document. You may need to disclose it for tax reasons or to public agencies if you're applying for benefits, but there's no database of this anywhere. It's not a searchable public document. Another sort of term I want to demystify is sometimes we'll say assets titled to the trust. For example, you can go into a bank and open a checking or investment account titled to John Doe, or it could be the John Doe Special Needs Trust, and the trustee is the one going in there to open it up with a copy of the trust and the tax number for the trust. So it can be as simple as a bank account, a brokerage account, it can be real estate. So a lot of different assets can be part of a trust, and you think of the trust as like the roll up, the umbrella entity that owns all these different assets. So it can be one account, it can be a lot of different accounts, can all be part of a trust. Okay, so now that we have this foundational understanding that a trust is a contract directing what happens to assets that are part of a trust, our next dive is into what is a special needs trust. So a special needs trust is regulated both federally and by state. So there are certain parameters that need to be met by the federal government in order for the funds in the trust to not be counted when you're applying for a federal benefit, namely SSI, for example. And then states often will incorporate the federal law and provide an additional level of detail or terminology. So it's really important to consider what state does that beneficiary live in where they're applying for benefits. Some of the key features of a special needs trust, whether it's first party or third party, and I'll explain that terminology in a minute. But the primary reason we use a special needs trust is to preserve the beneficiary's eligibility for means-tested government benefits. And means-tested just means that we're looking at whether they have a certain amount of assets in their own name. So whether they have a certain amount of assets, benefits such as SSI. So in a special needs trust, if we take, we're talking about John Doe, and John has a daughter, Mary, who has a disability. She cannot have assets in her own name. So John sets up the Mary Doe Special Needs Trust. Mary doesn't own it. For the purposes of benefits eligibility, it is not counted. Mary's creditors can't get at it. Mary can never compel distributions. It is what we call a purely discretionary trust. In no event is the trustee directed that they must make distributions from the trust to or for Mary. So there's no mandatory income to Mary. There's no requirement that the trust pay rent for Mary. It has to be a purely discretionary trust in order to be considered an appropriate special needs trust. And the reason for this is because the government understands that people with disabilities essentially are having assets set aside for their benefit, while the government is paying sometimes a lot of money, 6 and into the 7 figures of benefits for someone while they have these assets protected. So with that agreement between the disability community and the government, part of the way that the government requires these to operate, it has to be a purely discretionary trust where the trustee in their sole and absolute discretion make distributions. There are things that the grantor, meaning the person establishing the trust, can do to provide instructions on what their hopes are for the trustee's spending of the money. But that's not binding. And I would say it makes it so important to make sure you choose a trustee that aligns with what you would hope for the beneficiary, and maybe take advantage, at least in Maryland, I think in most states now, you can have a trust protector. So we can talk at another time if someone has questions about trust protectors, but another mechanism to try to make sure the beneficiary's needs are advocated for. And the last thing I'll say is that a sort of foundational concept of special needs trusts is that they supplement, not supplant, public benefits. So they're meant to be in addition to what the person is receiving, but the funds are not to be used to pay extra to the caregivers or replace what Medicaid is covering. So then we've gotten what a trust is, what a special needs trust is. Now we're going to dig into the next layer, which is first party versus third party. So first party means the money belonged to the individual who has the disability. It can be their savings from wages. It can be from their SSI or disability, a child's benefit. It can be gifts or inheritance that were given directly to the individual. That is all going to go into a first party, and I'm going to explain the difference in a few minutes. If the money never belonged to the individual, even for a minute, then it's a third party trust. And that's what you want to set up in your estate planning. So this is when gifts are made, and it is specifically says the Mary Doe Special Needs Trust. It doesn't say to Mary Doe, because then Mary owns it and it's going into a first party trust. It's inheritance through a will or designated beneficiaries that is directed to the Mary Doe Special Needs Trust, not to Mary Doe. Similar with life insurance. Do not commingle funds. It is a massive problem, and it can be untangled. It is going to take a long time. It could incur penalties. It certainly could risk benefits eligibility. So do not put your child's SSI benefit into the trust that your attorney drafted for your estate planning purposes if it's clear that's a third party trust. So we're going to talk about what you can do when that child is earning such that they don't have expenditures where the money needs to go every month, and they're earning or receiving benefits that could put them over the asset limit on the first of a month, but it can't go into the third party. And it would be very inadvisable to put third party money, meaning money from someone else, into a first party. Okay, so why is this? What is the difference? Why does it matter? Well, from a practical perspective, probably one of the first reasons it really matters is that the first party special needs trust has a payback provision. To be a valid first party trust, it must have a provision in there that says, upon the death of the beneficiary, if there's any money left, any assets left in this first party special needs trust, then if that person ever received Medicaid services, waiver services, the state that paid for those services is entitled to pay back for whatever the amount of those services were. So to make that concrete, if I have a beneficiary, Mary Doe, lived in a group home for years, received Medicaid waiver services, it is not unreasonable that if she received that for decades, she could owe well over $1 million back to the state of Maryland for the expense of the cost of those services she received. So any money left in that first party, the first step is it all has to repay the state of Maryland. It's only if they either never received Medicaid services from any state or they pay it back and there's still amount left in the trust, then the person who created the trust, the grantor, can have directed where it will go to family or, children, whatever. So the payback provision is an essential component of a first party trust. In our state, the trust has to be approved by the Maryland Department of Health. It must be irrevocable. I think irrevocability is a federal requirement. It has to be for the beneficiary's sole benefit. There has been some evolution on what sole benefit means, but it certainly means that the trust document itself can only have one beneficiary. It can't have sort of, Mary Doe and her sister Rachel Doe, who also has a disability. The trust itself can only be for Mary. In our state, once a person with a first party special needs trust begins receiving Medicaid, then at that point there's an annual requirement for an accounting to the Maryland Department of Health. So those are really important considerations for the first party trust, is that for this to be an appropriate first party special needs trust and be exempted or not countable for the purposes of benefits eligibility, it's got to have that payback provision. And I would say that while the money can be used for a great number of things for the person's benefit, there are more rigid considerations with the use of the funds. One piece I just want to point out, because you have a choice with these trusts while the beneficiary is alive, whether you use their social security number or you get the trust its own tax ID number from day one. As money is spent from the trust on for that person's benefit, for reasons that are probably too much to cover in this exact moment, but it may be tax advantageous that the accountant at the end of the year issue what's called a K-1 and assign any income from the assets in the trust, say it's generating interest and dividends, to the beneficiary, because they're going to pay tax on that at a much lower rate than the tax rate. I just want to make sure it's very clear to everyone listening to this seminar that taxable income is not the same as income counted for public benefits purposes. Social Security Administration and your state's Medicaid department understand that people may receive a K-1 that assigns income that will show up on their tax return. It does not mean that that income that they're receiving is going to put them over the income limit to receive the benefits.
Lilly, can we pause for a quick question?
Please.
Thank you. So question is it wise to open a specific bank account solely for income/assets for the beneficiary now before the special needs trust, either first and third, goes into effect?
Well, if they're receiving public benefits, you're probably going to have a representative payee account set up the way that Social Security Administration wants you to set it up. So that will already exist to receive their income. My general advice, and this is just general observation, is that if they're under 18 and their disability is such that you know they're going to need to apply for these benefits. This is not a case where it's sort of unclear what their trajectory is. I would not recommend opening an account in their name because it's going to be an asset to them when they turn 18. And you're not going to have authority as their parent necessarily to move the money once they're 18 if it's in their name. It depends on if it's opened as a custodial account and the rules in your state for whether parents retain access until the child's 18 or 21. So it's very dependent on the child's age, their trajectory for needing benefits, and where the money is coming from, what would make sense for that individual child. But I would be hesitant to just open an account for the sake of quote unquote the appearance of equity, just because that's what you did for your neurotypical or able-bodied children.
Lilly, thank you.
So that's the first party. Here's the third party. Oh, and just to clarify, I mean, you can't open any trust account until you have an established trust, which is a signed trust. So the trust is not going to exist until you've signed the documents establishing it. So it's you're not going to go to the bank and say, I want to open a trust account and not have a trust document. The third party trust, it's really important to get your head around this idea of constructive receipt, which means it doesn't actually matter if the beneficiary never physically had the check in their hand or never had a bank account opened with money in it. Constructive receipt means grandma, with the best of intention, left Mary Doe money directly. Mary Doe receives SSI, can't have the money. It's too late to get that money into a third-party trust unless there's something in the grandmother's estate planning documents that would allow that fiduciary to move it that way. The money has been left to Mary, and so she has constructive receipt. Whether she disclaims, which is inadvisable, or you go to get a court order to direct the money into a first-party trust is an entirely different conversation. But that money from Mary's grandmother cannot go into a third-party trust at that point because Mary has constructive receipt. She has control even for a moment. So this is appropriate where it was never the beneficiary's money. So the grantor or whoever is directing, whoever's establishing this trust, this third-party special needs trust, we'll call that person the grantor. They get to direct what happens to the money in there after the beneficiary's lifetime. So it's got some of the same concepts we discussed in that the money is supposed to be used for that person's benefit, but there's more flexibility. There's no reporting to the Medicaid department to get approval or sending accounts on an annual basis, accountings on an annual basis, at least not here in Maryland. So the money, the beneficiary never owned it. They have no control over it. It, depending on the benefit, may not even be something that has to be reported because they don't own it. It's not under their Social Security number. Depending on the drafter, some attorneys will draft it so that the trust can be revocable during the grantor's lifetime. That's a discussion to have with your attorney. In general, it's just a bit more flexible. And so it's really beneficial to have a third-party special needs trust lying in wait as a receptacle for your child with a disability. It may go unfunded for some period of time, but having it available is the proper avenue to protect their future benefits eligibility. So let's recap. We've talked about a trust, a special needs trust, and first versus third party. What do we have left? We're going to talk about directed and pooled and an ABLE account. Okay, so these are, we're more than halfway up the summit. Directed versus pooled. And pooled is a standard term. You know, directed, I would say it's may or may not be that if you Google it or talk to your attorney that directed is the term they'll use, but in short, it means you have had drafted for you the special needs trust for your child. So it could be freestanding. It's its own sets of paper with a title on the front, and it itself is a freestanding trust. It could be a testamentary trust, meaning it is embedded in your will. It is an article in your will that lays out the terms of the Mary Doe Special Needs Trust. Or it could be a subtrust, which means the Mary Doe Special Needs Trust is embedded in your revocable trust. So it will always be tied to your trust, and then the Mary Doe's specific trust is within it. But that's what directed means. You can name the trustee. It could be friends, family, or a professional trustee, which could be a corporate trustee like a bank. It could be a nonprofit trust company as the trustee of your standalone directed special needs trust. The other option is a pooled trust. There are nonprofit trust companies that have received the state's approval to operate a special needs trust, both first party and third party, and you can join it, essentially have a sub-trust within their master trust agreement. So you join it subject to their terms and conditions. The trust company will be the trustee. Depends on the trust company whether they also manage the funds or they will allow you to keep the money wherever it is being invested now, or they have a partner that they usually use for investments. So there's many trust companies out there, and they operate differently. So it is a consideration based on the makeup of the assets. Typically, I don't believe they'll accept real estate. I don't think that can be part of a pooled trust, but Cortney, you can correct me if I'm wrong.
Actually, a lot of them are moving to allow real estate. The Arc of Northern Virginia will allow real estate in their pooled trust, but the real estate has to be approved. So what the trust companies, the pooled trust companies will do is they will make sure that there is enough assets in your child's portion of the pooled trust to maintain that property, right? They don't want the real estate to be a drain on assets. So as long as it is financially viable, you can hold real estate in pooled trust, but it is pooled trust specific. Not all of them do.
Thank you. So certainly you need to interview and talk with the pooled trust company before you make any kind of plans that in your mind is concrete, because they don't have to accept it. They can evaluate it. And so you'll want to be interviewing them and understand how they operate. This is just a summary chart. I'm not going to spend a lot of time, but there's lots of specificity for how you mix and match first and third party, directed or pooled, who can establish it, how it works, what the distribution upon death rules are. So the last piece for special needs planning I want to talk about are ABLE accounts, because these are relatively new, less than 10 years old, that are a wonderful opportunity for people with disabilities to continue to save funds. As far as I'm aware, they're all online platforms. I put both the Maryland and the Virginia links down below, but you can have one account. You can choose what state you want it to be in. So generally the rules are that you can contribute up to the IRS gift tax exclusion amount for that year per year. So this year that would mean you can contribute up to $19,000 into a person's ABLE account. You can commingle funds, whether it belong to the individual or it's a gift to the individual. So if grandma means well and writes a $5,000 check directly to Mary Doe, it does not mean you have to open a first party, go through the steps with a first party. If that's the only thing in Mary Doe's name, you could just open an ABLE account and deposit it in there. The funds can be used for qualified expenses, so you'll want to understand what would qualify, but it is pretty broad what the money can be used for. And in terms of asset protection from eligibility purposes, the current rules, and I really want to emphasize that rules do change, but these are the current rules as of 2025, is that a person can have up to $100,000 before the funds count for SSI eligibility purposes. So if they're on SSI, you need to keep the total balance under $100,000. So this is not without some important limits. And you'll just want to, whatever your situation is, benefits wise, really understand what that particular ABLE account organization's rules are. The last thing I'll say about ABLE is that the current rules through this year are that to qualify to open an ABLE account, the disability onset has to be prior to age 26, but that's actually going up to prior to age 46, which is really wonderful because some people have conditions that don't present or they don't get the diagnosis until later in life.
Lilly, can I add on to one thing on the ABLE account before you advance? Because I know I have the slide here, but since we're already talking about it, when you were talking about being, it is state specific, right? And some of the rules surrounding the ABLE account are state specific. For example, where Lilly is in Maryland, it's subject to Medicaid clawback. In Virginia, it is not. And also, in addition to the state plan online, like the Maryland ABLE or the Virginia ABLE account, there are also ABLE accounts that you can get at various investment companies. Some of them are state specific, right? So for example, if you open, I believe Fidelity is Maine. So if you just happen to have your brokerage and your investment accounts at Fidelity and you say, oh, I can open my ABLE account here and everything's in one place, it's a Maine ABLE account, which isn't necessarily a problem unless funds are left in it, right? Because Maine is a state that's subject to Medicaid clawback. So you kind of do want to pay attention to where you open it and how you open it and with whom you open it. Because the plans are governed by the state in which they are created, not necessarily the state in which you live when you pass away or when you open the account or any of that. So, sorry, just wanted to add that little tidbit.
No, that's excellent. No apologies. Okay, so we've gone through our building blocks of information, and in my experience working with clients, that usually leads to this conversation. Wait a minute, you're telling me my child could end up with 2 trust accounts and an ABLE account? Who is going to manage this? And the answer is maybe, sometimes. It's why I think it's really important as you have the bandwidth to start engaging with professionals, your financial planner, your attorney, your tax advisor, and your family to figure out what is going to make sense and do some forecasting the best you can, at least for the medium term. So I'm just going to briefly change gears. We're going to go through this last section fairly quickly, but I think I would be remiss to talk about special needs planning and not just cover who has the legal authority to act on behalf of an adult who has disability, which really revolves entirely around the degree to which they have capacity. So if they have capacity, and capacity is not a singular definition, it means different things in different contexts. But if they generally can understand, for example, the importance of money and what they own and can name who they would want to have help them, then they can do a financial power of attorney. That might be the best bet to assist them so that someone can help them with banking, signing contracts, signing their own tax forms. Some states, I don't know about Virginia, Maryland and DC both have a statutory form for the power of attorney. The most important thing to understand is it is up to the adult, and you're not going to get anywhere to say, you know, oh, I want to have power of attorney over my child. I understand what the person's getting at, but that's not we need to reframe how we think about it, because it's up to that adult if they do have capacity, if they want to sign the document and who they would want to name. Same concept for healthcare advance directive. It is not to replace the person's decision making at all. It is to help them. I think that's the most important idea for parents to understand with the transition from their child being a minor into adulthood. This also gets into the concept of supported decision making. States are increasingly passing laws to enshrine the right to supported decision making, to assist adults in obtaining support, communicating their decisions. This is not replacing a power of attorney or advance directive. It can be oral or in writing, but it's more meant to organize the thoughts and plans for who can be in a room to help someone be able to understand, process, communicate their decisions. So it's really meant to be additive. It's not replacing the legal process. Oops, sorry, wrong way. And the last thing I'm going to say very briefly is just about guardianship. So this is in the event if the disabled person does not have capacity, where they simply could not, if I asked them, you know, if your mom gave you $20, what would you do with it? And I get no response. This person has no concept of money. I ask them what month it is. They have no concept of time. I ask them about their doctors. They may have some remembering of who their doctors are, but they can't articulate anything to me about a preference one way or another. Then that's when we're going to be talking about guardianship. These are state rules, so you need to talk to an attorney in the state where the person with the disability lives. That would be where the guardianship would be initiated. In our state, we have two types of person, which is your physical well-being, and you could sort of think of it generally as aligning with your healthcare advance directive, and the other is a property. So that's very generally aligning with what a financial power of attorney would do. It's a court process. It is legalistic. It is permanent. So it's something to be taken into with very serious consideration. But I do think it's important to know, because as your child enters adulthood, it's just a piece of the estate planning considerations. So we've gone through today on my side of the presentation, special needs planning, the trusts and the ABLE account, and looking at what would be the proper type of planning for the person with a disability. And with that, I'm going to turn it over to Cortney, who's going to pick this up and carry it forward, talking about the financial aspects of considerations.
All righty, let me just.
Thanks. Let me get that presentation mode transitioned over to you. Okay, you should see that button pop up on your end.
It is going, it's just going slow. There we go. All righty, there we go. Thanks all. My name is Cortney Heykoop. I am a financial advisor and chartered special needs consultant, and I work with Clover Wealth Strategies. We're a financial planning firm that primarily focuses on families like mine. After Lilly entered our life, oh, did it go away?
I see you.
Do you see my screen still? Oh,
yep.
I can't see my screen anymore. I don't know why.
Okay. Let's try this.
Oh, there we go. I'm sorry. I have it back.
Okay.
I clicked on the wrong button. Sorry.
Good.
So after Lilly entered our lives when she was 2, I went back to work. I realized there's not a lot of financial advisors that really focus on planning for families like ours and why it's different, right? So Lilly is now 20. and learned a lot of things along the way. Please remember, this is an informational seminar. We talk a lot about legal things and talk a lot about tax things, but we always want to make sure we are talking to someone like Lilly on the legal side, or a CPA on the tax side. When we talk about financial planning in general, right, I always view it as Mount Everest, but we're planning for the ascent and the descent, right? So what are some of the goals and challenges we have along the way of getting to the point at which work becomes optional? And then how do we navigate coming back down the other side? And for families like ours, that's incredibly more challenging, because we're planning for a retirement that could include 3, and also planning for our life for the life of our adult child once we're gone. So that descent is a little different as well. I look at special needs and disability planning as an advanced planning strategy, and it really closely incorporates the disability planning, which Lilly has discussed, like managing your government benefits and navigating Social Security and Medicaid, tax planning, estate planning, and also financial planning. The first thing I always tell parents is you have to put your air mask on first, right? Because, and honestly, we're planning for a retirement of 3 in some way. Whether your child gets an apartment and lives independently with supports, they're still not fully launching, right? We're still supplementing, we're still involved in some way. So we need to make sure that we're in a place that we are safe and secure, so that we can make sure we can best care for our child. So the first thing we want to do is make sure our financial plan and our finances are in order. And we want to do that in a way to make sure we have an eye on our child, because the decisions we make as we put together our financial plan surrounding things like Social Security, surrounding cash flow, will have an impact on them. I always tell my clients to remember that retirement looks very different today than it did a generation ago. And I always tell by the stories of Lilly and Patty. That's Patty on the screen there. That's my mom. She's now 70. She travels all the time. Actually, she's on a plane ride back from Budapest right now. I have to pick her up at the airport tonight. Where if I look back a generation at my grandmother, she lived in the same house that she raised her kids in. She didn't travel except if it was like one of my dance competitions or my brother at a hockey game or something like that, right? Retirement looks different. It costs a different amount of money nowadays, and how we plan for it's different. So we want to make sure we're taking into all of those challenges in our own retirement, like inflation, market risk, longevity, the safe withdrawal rate, surviving the loss of the spouse, and also, sorry, I hit that first, taxes, right? When we focus on the special needs planning side, like we went through with Lilly in the first section, the estate planning is critical. Coming up with the trust and the construction and the execution of those. I work very closely with my clients, helping them coordinate with their attorney to make sure they are managing and administering the trusts correctly, right? Making sure they're in contact with the right people to make sure they're doing things correctly. Analysis of the government programs, the timing and benefits. For example, Lilly talked a little bit ago about the adult disabled child benefit, right? So once I start receiving Social Security, my child could potentially begin receiving 50% of my primary insurance amount, which is typically a lot higher than $967 a month. When we get into those factors as a financial advisor. I'm not looking at how do I maximize mom and dad's Social Security, but I'm looking at how do I maximize household income, right? Because retirement isn't just mom and dad anymore, or the two parents. It's the entire family, right? We have an adult disabled child that could be potentially living with us. So how do we navigate that? And also, you know, working on how we are going to fund that special needs trust, right? So if we have different amounts of money coming in from Social Security, is like Lilly said, that cannot go into a third party trust, but are the parents receiving a reimbursement from a lodging agreement, and what do they decide to do with that money? Could it be to utilize to purchase a life insurance policy or make contributions to other types of investments? So there's lots of things that we can get into there. And all of this is really done in conjunction with the parents' plan, right? How do we take care of the child as we plan for the parent's future, right? What does that look like? And of course, as Lilly said, the decision between guardianship and supported decision making.
Hey, Courtney. Sorry to interrupt. Sorry to interrupt. It seems like your slides might not be fully advancing. Can you try to advance a slide? If it doesn't advance, then we may need to.
Go to one that says government trusts.
Yeah, we're not there yet.
Okay, hold on one second.
I can take the slides back over and then have you open them back up if that doesn't work. How about if I take the slides back as, oh, there we go. Looks good.
You can see my slides?
Yes.
No, I can't. So that is funny.
All right.
Okay. I'm going to stop and going to go back to it here. It says, are you seeing government programs available now?
Yes. Yes. Thank you so much.
And is it advancing when I hit that button?
Yes.
Okay.
Thank you.
A lot of, you know, some of my presentation overlaps with Lily's, and I'm not going to go into great detail around these because we've already discussed that, and I would like to get us kind of more into a questioning session so we can go through those. But I do want to dig a little bit deeper into the Medicaid waiver programs. We talked first about Social Security, the supplemental Social Security income, the $967 a month. I put on here Social Security disability income. Most of our kids aren't actually going to receive SSDI. They are going to receive, like Lilly said, the disabled adult child benefit, right? But most parents will say, my child receives SSDI. Legally, technically, SSDI is on your own record, not your parents' record. Some kids might have that if they've worked, but for the most part, when parents say, oh, my child's now getting SSDI, they're referring to that disabled adult child benefit. So that gets us into the Medicaid waivers. These are really in so many ways so much more beneficial to the family and the individual than the $967 a month, because how far does that really go? But the Medicaid waivers can provide job supports. They can provide your housing supports. It also provides just personal care attendant hours, which for many families is their lifeline. You know, somebody that is there to to make sure that your adult child gets ready for their job or their day program every day, or that is getting your child out into the community, and doing a variety of different things, making sure they're eating and meal prep is done, all of that. And those services, the value of those is really so significant. So we want to make sure that we are applying for Medicaid waivers as early as possible. We understand the waiver program within the state in which you reside. And we're, working very carefully to maximize the benefits that your child can receive. Because it's, in a lot of cases, if you don't know what to ask for, the services aren't necessarily just volunteered. So you want to, unless you have an amazing case manager, but the case managers inside Medicaid are very overworked. They have huge caseloads, and there's a lot of turnover. So your support coordinator just might not have the knowledge or the capacity to kind of track down the different programs that you need. So that we want to make sure we're staying on top of all of those. We went through what a special needs trust is and why they're important. A couple of things that I want to kind of add to on the ABLE accounts. Not everybody needs one, right? Like, in my mind, it's another tool in our pocket. And I recommend most of my clients have it. When they first came out, people thought, oh, ABLE accounts, I won't need to spend the money to get a special needs trust done anymore. That's not the case. They are not a replacement for estate planning. That $100,000 is a very low limit in the long-term scheme of things. But it is a very important account to have. And I recommend my families open it when their child is younger, because it is easier to do when you're younger. If you apply for it at your 27 and you have to prove that the disability existed prior to 26. If you apply for the account and it's established when you're younger, it's just much easier. There's a couple main reasons, getting into talking about how do we use it, right? The number one thing that I point out is that your special needs trust cannot be used to, and Lily, tell me if I use the word wrong, supplant what your Social Security payment is supposed to cover, which is your room and board, okay? So your special needs trust cannot pay for housing and food. The ABLE account can pay for housing. If you pull up ABLE and you look at the list of qualified disability expenses, housing is one of those. So parents can transfer up to $19,000 a year from a special third-party special needs trust into an ABLE account, and that can be used for housing. So there is a housing loophole there that helps us to maintain a quality of living that is above the poverty level, because when we think about Social Security is really keeping someone at that poverty level when you only have $976 worth of income. So that is the biggest kind of struggle parents come up with, is I don't want them living in a house that, they can afford on $976. So what are our options? An ABLE account is a great way to do that. Another way that a lot of my parents will use it is, say your child has a part-time job at Costco. Costco has a great 401k plan, and for most of its employees, they think it's fantastic, because whether you put money in it or not, Costco is going to add 4%. For our kids, that's a problem, right? Because that's an asset. So parents will often have to take the money out of the 401k plan before it gets close to any significant balance and put that somewhere. Where can they put it? An ABLE account is a great place. We did talk about also the gift limit, the gift exception, which this year's the 19,000, is how much you can put in. If your child works and their income is below the poverty level, then they actually can put in more than the 19,000. They can do the 19,000 plus the state poverty level, state dependent. So not all states allow that, but it is something to take a look at and see if your state does offer that. And the other thing we talked about that's very important about ABLE accounts is that Medicaid clawback, as to whether or not you can list a beneficiary if it's going to stay in the family, if it's not all used, or if Medicaid will take it back. So you want to make sure you know that and potentially spend the ABLE account prior to any money in a third-party trust. If it's not subject to Medicaid clawback, then of course we're spending first-party money first, then the ABLE account, then the third-party trust. But potentially the third-party trust before the ABLE account. And the reason is the ABLE account has some nice tax benefits. So ABLE accounts are built on the same chassis, the same platform as the 529 plan, okay? So when you make a contribution, depending upon your state, there is a state tax deduction. Now, it is not going to be equal to the amount of a deduction, the state tax deduction you get for putting money in a 529 plan. For example, in the state of Virginia, you can put $4,000 per parent into a 529 plan and get basically an $8,000 state tax deduction per child, right? Only $2,000 for an ABLE account, period. So it's not as much of a state tax deduction as it is into a 529 plan, but there is a tax benefit to doing that. And if you are highly sensitive to taxes, that's a great thing to look at. Also, the money grows income tax-free as long as it is used for a qualified disability expense. Money that grows inside your trust could have potential tax consequences. So how what money you have in which account and how you utilize it, which ones you use first, can have a tax consequence, okay? The biggest thing I get, parents will come to me and I'm asked kind of the same standard questions all the time. The first one is, why do I need a financial advisor that is paying attention, that it has a chartered special needs consultant designation? And as I said, our planning is different, right? And you need an advisor that really understands Social Security and Medicaid and ABLE accounts and all of that. And a lot of advisors, that's just not their specialties. They just don't have the background in it. The second question I get is, okay, I just visited Lilly. We set up our special needs trust. How much money do we need to put in it, and how do we do that? And how do we fund it? And those are very big questions. The first one, how to fund it, is easy, okay? There are two ways that special needs trusts, well, there's three, two of them are the main way. There's three ways that special needs trusts are funded. One, you put money in it, right? If your household has excess cash each year and you're looking at how do I want to save and invest and where do I want to put this money, you might make a contribution every year into that special needs trust. More than likely, your trust is going to be funded in the other two ways, inheritance or life insurance. When you pass, that life insurance, that permanent life insurance policy that you have is going to go into your special needs trust. The second way is inheritance. I leave money to my child's special needs trust, or grandma, grandpa, aunt, uncle, friend, whomever might be leaving money into that special needs trust, right? So those are the main ways that we want to look at that. And then the next question is, how much do we need to put in there, right? That's the kind of the more difficult question. When it comes to inheritance, we can, as financial planners, foresee to a certain degree, a probability of success, how much is going to be in your estate when you pass away. We can stress test that. We can come up with worst case scenarios. We can come up with best case scenarios. But we're going to eventually come down to a decision of, say we need X amount of dollars in the special needs trust. And we've done some calculations, and we think based on what we are supplementing now and what we foresee needing to supplement once we're gone, our child's going to need X amount of dollars per year. Then I'm able to say, okay, then we need an inheritance of X amount of dollars. If what you're able to leave your child isn't that much, or we're concerned that a parental long-term care event is going to decrease the amount of money that your child will inherit, we need to make some plans for that, right? So how we fill that delta is really through life insurance, because that is a way for us to guarantee X amount of dollars is going into the trust, regardless of what happens to my financial portfolios. If I have Alzheimer's and I spend 9 years in assisted living, how is that going to affect my child's inheritance, right? So we're able to take a lot of that risk away from the special needs trust through the use of life insurance. We can also do some strategies with hybrid annuities and life insurance with long-term care provisions. We can get very specific and tailored, utilizing life insurance to protect both your financial plan as well as funding of the special needs trust. But life insurance is incredibly important to families like ours, because it helps us mitigate that risk of what will happen if the amount of money I hope my child will inherit isn't going to be there. So people, ask me frequently about, well, when do I get life insurance? Or, Cortney, I'm in my 40s now. I have term life insurance. When do I need to convert that to permanent? And it really depends upon your goals. It depends upon your cash flow, and it depends upon, your health and genetics. Premiums increase with age. So the longer you wait, the more expensive permanent life insurance is going to be. Additionally, our health changes. We're only ever one doctor's appointment away from a more expensive life insurance policy, or God forbid, being uninsurable. Also, depending upon how we want to use life insurance, the longer we wait, the less amount of time we are given that policy to have cash value growth. So life insurance can build cash value inside it. There are both fixed life insurance and variable life insurance that can grow cost or grow cash value inside it. And depending upon our plans, we might want that cash value to potentially be a down payment on a condo or an apartment for our child, right? Or we might want to utilize some of the cash value to offset potential long-term care for ourselves so that our inheritance can go on to our child. There's a lot of different things that we want to consider there when we decide on our timing and our approach to life insurance. Also, when we're discussing, what assets are going to go into the trust, we need to get strategic on that, because with the Secure Act, not all assets are created equal. and you'll see at the end of my slide, I put up I have a little picture that has hung on my refrigerator since my kids were 3 and 4 years old. Fair is not equal, right? And that comes down to our assets that we're leaving to our children as well. Retirement accounts used to be able to be stretched over the lifetime of the beneficiary that is receiving them, right? So for example, my retirement account that I have, I will eventually have to take required minimum distributions. If I pass, whoever inherits my account will have to take required minimum distributions. It used to be that that could be stretched out over my lifetime. So if I inherit $1 million from my father's IRA, I can stretch that out over my lifetime. So my required minimum distributions will be much smaller because I can stretch that out over 20, 30, how many ever years of life I have left. Doesn't work like that anymore. Now we have 10 years. So if I inherit $1 million, I have 10 years to liquidate that account, which means I'm going to have to take out $100,000 per year, right? My father passes away when I'm in my 60s and I'm at my highest earning years. So my husband and I are both making a great salary, and now I have to add $100,000 of additional income on there. It's going to have a huge tax consequence. However, the Secure Act does allow that if a special needs trust inherits that it can be stretched out over the lifetime of the special needs trust beneficiary. So my retirement accounts may make sense from a tax perspective to be left to my special needs trust for my one child, where another asset might be best left to my other children and my family trust, right? So we need to dig into and look at the tax consequences based on your family, how many kids you have, how much money we expect to have in your retirement accounts, what your tax rate is, what the trust's tax rate is, what your, there's a lot to consider there and a lot of advanced planning that we need to dig into. But we want to kind of just instill to you today that not all assets are equal, right? So we want to look at that. Strategies for gifting during your lifetime. A lot of times parents will tell me, I'm not charging my child rent. Why would I charge my child rent? First thing, it's not rent, it's a reimbursement of their share of the expenses for the household because they're an adult now, right? And they should have housing costs just like the rest of us, right? Social Security also requires that if you are not, or if you are supporting them and you are not charging them for their room and board, they are going to reduce that $967 by a third. So you're now only receiving $600 and change, $620 at the most, right? So you need to charge your child a lodging, create a lodging agreement and charge them for reimbursement of their fair share of the house. Now, Social Security does recognize that even the full 967 might not be adequate to cover their fair share of the house, depending upon where you live and your, cost of living in your area. So it just needs to be a competitive amount. I have families that charge anywhere from $500 a month to $800 a month. It really depends on your situation. But having that lodging agreement is very important. But that comes back to the parents saying, well, I don't really need this money, or, what can I do with it? Well, it's now your money. So you can turn around and gift that money to a special needs trust. You can turn around and use that money to purchase life insurance on yourself. You can do a lot of things to help start planning for your child's future with those funds, okay? We did get into a little bit the leaving your home to the trust. even if it is a personal trust. You need to have some good, solid conversations with the trustee, the successor trustee, your financial advisor, before you just leave the house outright to the trust. You know, for example, I've had a client who recently said, this is the only place my child has ever lived. If we take him out of this environment, it's going to be detrimental. We want him to live in this house. There's no other siblings. There's no other close family members. So in addition to the cost of their child living in that house, right? They are going to have to pay for somebody to come in and take care of, be a property manager, as well as be a case manager or life care manager for their child, making sure that, you know, they're getting to all their appointments and they're, you know, getting fed, and the support staff is showing up and working or hiring new ones when they leave, all of that. So we want to make sure that if we're leaving a home in the trust for your child to live in, that there are adequate resources in the trust to support that. And that is also, like we discussed earlier, a pooled trust. They will vet that. They will come back and say, we can't support the maintenance of this house, right? So you want to make sure that we're looking at that. You know, it could be that the home is liquidated and the assets go into the trust. That's a much cleaner kind of scenario. Also, investments or businesses. If you are a small business owner, or you have a very, you know, you have a partnership in a business, something like that, and you want to leave your partnership interest to the trust. That trustee is now going to have to manage that. So is it better to liquidate that interest? How do we want to structure that? You want to work very carefully with your attorney to make sure we are going through how to handle the business prior to it just going straight into the trust. Investment properties also, we want to discuss how they're going to be managed. Or even just complex investments. Your trust could continue to be managed by your existing financial advisor. Some corporate trustees will make you liquidate and be, you know, they will manage the assets. Some corporate trustees will allow you to retain your own financial advisor. Retaining your own financial advisor, I have a bias towards that, just because I think that it adds a level of consistency and helps with that next generation, helping them to know, you know, I can say, oh, well, your mom or your dad purchased this investment because of XYZ, and they, you know, they're expecting this. So it gives some background and some continuity there. Life insurance, of course, who owns the life insurance? The special needs trust itself can own the life insurance. You can own the life insurance. And, you know, that being left to the trust, of course, is one of the easiest, cleanest assets. All of this takes a lot of collaboration between your financial advisor, your estate planning attorney, if you're working with a corporate trustee, that trust officer, CPAs, and potentially your banker. You know, if you in all likelihood are going to need a checking account in the trust name at some point, so the trust can pay bills or, you know, purchase the stair lift or any of that. So you want to make sure everybody is working together and that you have a good relationship through there. The next generation of care, I have a whole seminar on this, and it's one of the most popular seminars I've done this year. Because as we as parents age, that huge question of who will take over care for my child when I'm gone, right? But also who's going to take care of, like Lily said, I might have 2 trusts and an ABLE account. Who's going to take care of that? It could be the same person. It could be 2 different people. coming up with who that's going to be and what that's going to look like, there are a lot of questions and soul searching that go into that. And thinking about what information and education they need. Take a look back, one seminar Lilly and I did, was that last month, I think, on the family love letter and documents for life, because that it really is how we are going to prepare. It's the most amazing gift that we can give that next generation, is that knowledge and preparation and organization, to make sure that they have all of this and they know what we've done over the years in preparation. They know why we have a first party special needs trust, why we have a third party, what they need to use the money for, what we want them to use the money for. You know, it's important for us that our child, you know, maybe sibling lives on the other side of the country, or favorite cousin or aunt lives on the other side of the country, and we want to make sure they visit them once a year, or we want to make sure they get to the beach every summer. Whatever that may be, the family love letter, it helps us prepare for that. Okay. And none of this is one and done. Your estate planning, tax planning, financial planning, and disability planning needs to be done on a consistent, continuous basis. Some of those things might be an every year thing. Your financial plan might be a quarterly or every 6 months situation, where your disability and tax planning might be every year. And estate planning, you know, might be every 3 to 5 years, or when there's a huge change in or life milestone. But all of them are things that we need to continuously readdress. This is the picture that I was talking about that hangs on my on my refrigerator. But yes, fair is not equal, and we want to make sure we're setting our family up so that everybody gets what they need. And from a financial planning perspective, our long-term thinking and planning enhances our short-term decision-making. Making sure we have a plan in life in our hand that includes not just our financial plan, but our mission. What do we want out of life? What do we want all of this to achieve and give us? All of that goes into our plan, and is kind of the backbone for what I do. So my contact information is here as well. And I will go ahead and stop sharing, and we can open it up to questions.
Lilly and Cortney, thank you so very much. Such important and timely information. We do have some questions, so let's go ahead and jump into those. Regarding guardianship, for guardianship, what about the capacity of a person to make, quote, responsible decisions versus just the ability to make a decision?
So I can speak to Maryland specifically. In Maryland, the process is that we have to have 2 certificates completed by medical professionals, one of whom's a doctor, the other can be a doctor or practitioners in one of 3 categories. That serves as the foundational evidence for whether or not the person has capacity. So if you're, as a threshold, uncertain if guardianship is the right conversation, then I think having a one-on-one discussion about that makes sense. But knowing that ultimately, if a family wants to pursue guardianship, it's going to go through the process of gathering that medical evidence, which are these forms filled out, and then what the doctors say will really be informative as to whether they think the person can make decisions. So it doesn't necessarily mean that the person's always going to make what we would consider to be a prudent choice, because you are allowed to make bad choices. I think underneath that, it's whether or not you understand at all the consequences of the decision, or even the nature of the decision in itself.
Okay. Our next question is, are there advantages to replacing a previous revocable special needs trust to a standalone irrevocable trust while the grantors are still alive? Brian, it's good to see you here. Thanks for the question.
Fact specific. I can't offhand see what the advantage would be. If the original trust is not a standalone, I will say that some people prefer a standalone because if your special needs trust is embedded, meaning drafted within some other larger document, larger document is always and forevermore going to be what controls the terms of the trust. So probate, tax, government officials, other qualified beneficiaries named in the larger document are all going to be able to see what is there. And furthermore, the beneficiary is always going to have the right to see the document. So the full document that contains their specific portion. So I can't speak to revocability or irrevocability because I think that's a very fact specific question, but I will say as far as standalone, that's one reason people prefer to have a standalone as opposed to something embedded in an existing document.
Okay. Next question is, when you say it goes into a special needs trust, what does that mean? Does the life insurance or inheritance go into our bank account, or is this where a separate account comes into play?
So when I say the life insurance goes into the special needs trust, we set up the beneficiary of the life insurance as the special needs trust. So the money goes directly into a special needs trust. A special needs trust can be a variety of, so think of a special needs trust as a bucket, right? When I say it's going into the special needs trust, but it is really an entity. So that entity can have a checking account, it can have an investment account, it can have a savings account, it can have CDs. So, once, the life insurance company is going to cut a check to the special needs trust of, and then you have to decide where you're depositing that. Are you putting that directly into your investment account with your financial advisor, or are you putting it in a checking account and then transferring it over? It works just in the same way that a check would be left to you as a person, right? You can put it in whatever type of account you want. The trust has that same ability.
Okay.
Right, you own the policy most likely. It's when the insured person passes, where does the money get directed, just as Cortney was saying.
Yeah, and the owner of the trust can be the insured. The owner of the trust can be the special needs trust, or I'm sorry, the owner of the life insurance policy can be the insured. The owner of the life insurance policy can be the special needs trust. It can be either. It depends on the situation.
All right, next we have, are the costs for special needs financial planning allowable, able expenses?
Yes. Yep. So is tax preparation.
And next is, if I charge them rent, would I need to include that in my taxes?
It's a good, very good question. And I have had accountants answer it both ways. If you are charging an amount that is over the actual reimbursement, then no. So say Lilly and I have an apartment together, right? And I pay half the rent, but I'm sending her the check and she's paying the rent. That's not really a taxable situation. I'm just giving her the money so she can pay the bill, right? We're sharing the costs. That's a reimbursement, which is not taxable. So if, there's 3 of you living in the house and you add up all the cost of the utilities and the cost of maintaining the house and the mortgage and everything, and what you're charging is over that amount, you have a problem. That's rent. If it's under, it's a reimbursement of expenses and it's not taxable. That is what CPAs have told me. And most of the CPAs at the Academy of Special Needs Planners and things like that, that is the route that they go. But a lot of times you will come across a CPA that is not really understanding special needs laws, and they will go just strictly by that's a rental income. So sometimes you have to educate your CPA a little bit as well.
All right, so we have 2 more questions here, and then we'll end. What happened? Oh, actually, had another note and just took my question away. There we go. What happens if you're trying to apply for SSI and one of the parents is already retired? Can an individual qualify for both SSI and the childhood disability benefits?
So they offset each other. So you would apply for SSI and receive the SSI designation, and then you would call and say, hey, myself or my spouse has retired, and we would like to receive the adult disabled child benefit, or our child would like to receive the adult disabled child benefit. You get whichever is greater.
Okay.
You don't get both.
All right, and last one for now. Rachel, I will follow up your question directly after this. Our question for now is, does the 3 times poverty level calculation apply for waivers in Virginia? If moving from Maryland to Virginia, what advice should I seek before moving? And also, did you say rent can't be paid from a special needs trust?
Okay, so the 3 times the poverty level, it's not 3 times the poverty level, it's 3 times the SSI amount, which is $967 currently, right? That is the amount for waivers. So if my child receives the Medicaid waiver through my state, they cannot earn more than 3 times that amount without losing their Medicaid waiver benefit, okay? When you change states, your Medicaid doesn't go with you. You have to completely reapply. So say you're getting services in Maryland and you move to Virginia, they're going to stop the day you cross that state line, and you're going to have to reapply. And that process can be very lengthy. Depending upon what state you're in, the wait can be sometimes decades.
Insurmountable. I would strongly advise you consult with either a special needs attorney, a benefits counselor, somebody before making the move. If your child is outside of school, if they're still in school, I think you've got more flexibility. But if they're 18 and older outside the school system, there's no grandfathering in, there's no fast pass. You're completely a new resident starting at the back of the line based on that state's eligibility criteria. And I'm happy to have a meeting with anyone looking at moving to Maryland. I couldn't speak to Virginia, but I certainly could speak to what happens if you try to move to Maryland and receive benefits.
Okay. Lilly and Courtney, thank you so much. And thanks for.
Is long.
Yeah.
All right, Lilly, thank you. Courtney, thank you so much for your time today, your expertise. Thanks to our attendees for being here. So I'll be sending out information later today with our recording, the slides, contact information, lots more. Also, all the information from our first presentation about the Documents for Life and Family Love Letter. Our webinar series continues. We have our wellness series coming up about frauds and scams, trustee selection, talking about our client care program, and then on June 26th, hope to see you back here when we're going to talk more about the differences and how ABLE and special needs trusts can work together and much more. So Lilly and Courtney, thanks again. And thanks to you, our attendees, and hope you have a great weekend, and we'll see you again soon.
Thanks all.
Thank you.
Take care.
Bye-bye.
Thank you.